For being here today. Got a great turnout here today for Dr. Mary Elizabeth Wood, who is one of the forensic evaluators over at Vanderbilt University. And so we've had a lot of interchange with her over the years with some of the folks that she has served that are part of our system who are tangled up with the legal system. And so I'm so happy to have you here, Dr. Wood, with us today. And, we met a few weeks ago, or maybe I guess it's been a couple of months ago, maybe, about a study that you're interested in. I hope you'll talk about some today. And, this is a really, really key part of our system because we have people with IDD who get into this, get legal charges against them. And so we've got to sort out these cases and try to figure out who needs to stand trial, who doesn't. We need to figure out who should be maybe accountable for what they've done versus those who might need to just be supported more effectively. And so so happy to have you here today to talk to us about all this. And I'm going to just ask you to start us off with a little bit of an introduction of yourself. Tell us a little bit about who you are professionally and so forth. And don't forget to include that interesting fact about yourself.
Sure. So as Dr. Davis mentioned, my name is Dr. Wood. I'm over at Vanderbilt. I'm really grateful to be here. I think I'll point out now, but probably again during the presentation, this is a little bit unusual for me. I frequently talk about this topic, but usually the audience that I'm talking to are forensic professionals, whether that be the court or lawyers or sort of graduate students who are training in forensic evaluation. So it was a bit refreshing to prepare this talk today where I don't have to sort of cover the nuance of intellectual disability and what it is and what it isn't, but sort of get right into those legal issues. So I'm excited to be able to do that today. In terms of my professional background, I do have a doctorate degree in clinical psychology, and I completed a concentration in psychology and the law, meaning that most of my training and education sort of fell at this intersection of psychology and the legal system. And within that, a lot of my training was sort of in this area of intellectual disability. I was a member of an intellectual disability in the law research lab for 5 years during graduate school. And we did a number of research projects basically focused on sort of how do we diagnose intellectual disability? What are the different assessment instruments? How do they converge with one another? But also broader topics in terms of how does the court perceive individuals with intellectual disability? What are the stereotypes associated with this, as well as a lot of the problems that I think are really wrought in this area. And I'll be talking about some of those today.
Dr. Wood, I don't want to interrupt you too much, but I was curious as you were going through that, what drew you into this particular area of work?
So that's a good question. I actually, I was initially interested in sort of juvenile forensic psychology and sort of interested in how sort of cognitive development and how that kind of created difficulties for juveniles in the system. And then worked when I was an undergrad at a special school, a special day school for kids with learning disabilities, and really got involved in that area in terms of accurate assessment. And my graduate school mentor, I mentioned she sort of leads the intellectual disability and law research lab. A lot of her research sort of was driven out of the Supreme Court decision in Atkins versus Virginia. And it really, I think, highlighted the Atkins decision in 2002, really highlighted a lot of the problems in this area. And they were the same problems that I sort of picked up on with these juveniles involved in the system. And it really, I just realized sort of focusing on that these were really broader issues that weren't just specific to capital cases or the death penalty, but really sort of affected all stages of the process. So.
Thank you for that.
Yeah, absolutely. And I guess the other thing I would note, so I'm here at Vanderbilt now. The bulk of my responsibility here is to do court-ordered evaluations. And so I do interface quite a bit with DID in terms of I'll take all the cases that our office sees where intellectual disability is an issue. But I found since coming here that a bulk of my responsibility, sort of in some ways intentional, in some ways non-intentional, has been to provide education. And that education comes in the form of sort of every year we provide training to new defense attorneys here in Davidson County in terms of what the forensic evaluation system looks like. But since I started here, we've added a component to that training for intellectual disability and sort of identifying defendants who have ID, how to represent someone who has ID, and when to maybe refer someone for this type of evaluation. But I also really approach these cases where I'm called to testify as an opportunity to educate the court about intellectual disability, because I found that more so than in other areas, there's really just a lot of stereotypes and misconceptions about what intellectual disability is. And so much I feel like of my job is sort of countering those and explaining that, intellectual disability isn't something you can see, you can't hear it, you can't identify it on the basis of a conversation or an interview. And frequently these deficits that I'm going to talk about today really do go unnoticed. And so I think for a lot of those reasons, I view my role now sort of as a consultant to sort of ensure that these individuals are identified in such a way that they're not just getting passed through a system, that they're not really able to advocate for themselves. Now, in terms of the interesting fact about myself, I mentioned I had to consult with my husband because I view myself as pretty boring. But the best I could come up with, I think the most interesting thing about myself is my name. My name is Mary Elizabeth, but I've actually gone by M.E., so M period, E period, my whole life. And the reason for that is because my parents took me home from the hospital, and my dad's best friend looked at me and he said, "Gosh, Mary Elizabeth is such a long name for such a little person. I'm going to call her Emmy." And it's stuck. And I've tried multiple times to go by a real name. I tried to go by Mary when I was in graduate school, and Emmy's it. I'm just an Emmy.
Okay. Yeah. So now I'm not going to do this in a formal setting that we're in, but next time I see you, I'm going to call you Emmy.
Yeah.
I was interested to follow up in just one thing you said there.
Sure.
The Atkins decision, and we've got a bill before the legislature this year. I'm not sure if you've been following that, but there's a bill before the legislature this year about people who are death penalty cases involving a person who is suspected of having intellectual disability, and for them to get tested, have the ability to get tested so that can be verified or determined. I don't know if you've been following that at all.
I've not seen that. Is that something in Tennessee in particular?
That is a bill that's before the legislature this year for consideration, something that they're thinking about, because it's not always been required that if somebody did not have that pre-existing diagnosis, that they would be tested under that circumstance. And so I just was curious as to whether you had been following it at all. That's something interesting going on.
Yeah, and I feel like Atkins has really highlighted so many of the difficulties and a lot of the discrepancies in terms of how the court views these things versus how sort of they play out in real life. And the court really demands black and white decisions and deterministic sort of ideas, whereas we work in worlds where it depends and it's probability estimates. And so I think in this area, there's a lot of concerns about that.
Often seen where the clinical and the legal clash.
Oh, yes. Clash is a good word for it.
we experience that somewhat in eligibility requirements as well, because there will be, a pretty hard and fast rule. You got to have this 70 or below before age 18. And that's not exactly the way the clinical world works. We
right.
gather information. We get, from different sources, we come up with a diagnosis based on lots of different things, not just these kind of rigid rules. But
right.
That's I know that's a big part of the forensic work that you do.
Right. Right. Now, is it possible for me to share my screen? I think it is.
Yeah, I think. So you're going to share? Okay, I thought Trey was.
Did that work? Can you guys see that?
Good. Yeah, I see it here.
Okay. And can you see is it the presentation or just, is that?
It says intellectual disability and competence to proceed.
Perfect.
Yeah.
So I guess I'll just sort of move on from here, but please feel free to sort of interrupt or ask questions if at any point. I've sort of prepared this in a way to kind of provide an overview, but I'm certainly able and willing and open to sort of having this more discussion based, if that would be helpful.
Will we be able to get this slide deck?
Sure. Yeah, I can email it afterward. Absolutely. Let's see, how do I get to the... Okay, so I've already sort of covered this already, just sort of my background and sort of this intersection of psychology and the law, but really this interest in intellectual disability and how that falls at this interface of psychology and the law. And I don't need to get into this too much. You guys are all professionals in the area, but I do want to just point out when I'm talking about intellectual disability, I'm just referring to the broad classification system, the sort of concurrent deficits in IQ and adaptive behavior before the age of 18. You know, I could spend 5 days talking to you about sort of the nuance of the diagnostic classification system. That's really beyond the scope of this. I will note, though, that the majority of individuals do fall in the mild range, and 100% of the people that I'm going to be talking about today fall within the mild range. So these are really not contested issues in the court when defendants have more moderate to severe forms of intellectual disability. Those are situations where there's oftentimes no need for an evaluation. Sometimes they're diverted from the criminal justice system immediately. So those aren't really the cases that I'll be talking about. It's really within the mild range that I'll be talking about. Now, in addition to the IQ and adaptive behavior deficits, I do want to point out the importance here of associated social vulnerabilities, and these really create a lot of problems in the criminal justice system. Now, I will note that we know that individuals with ID are overrepresented in the criminal justice system. What's unclear is how overrepresented they are. So these estimates really vary widely from 2% to 20%, and they really depend on sort of if we're looking at samples of probationers or incarcerated persons, people referred for forensic evaluations. But despite the fact that it's well known that they're overrepresented in the system, we know that they're also under-identified. So these individuals are oftentimes going sort of under the radar. They're not being identified by the criminal justice system like correctional officers, but oftentimes they're not being identified by their attorneys either. And there's a number of reasons for this, one of which being that I think I've mentioned this already, that ID is really an invisible disability. It's not something you can see or hear. It's not obvious in the same way as someone with maybe a psychotic spectrum illness where you can sort of hear the delusional beliefs or the thought disorganization. I've also mentioned already this area is really wrought with stereotypes more so than other areas. I can't tell you how many examples I've seen of sort of stereotypes about what individuals with ID can and cannot do. So even in court settings, I heard a judge once say, you know, well, she was competent enough to drive a car, therefore she's competent enough to stand trial. And as I'll get to in a minute, that's a very different standard. And there's really not a lot of convergence between the ability to drive a car and the ability to stand trial. And certainly I think these misconceptions sort of lead to under-identification. The other thing to note is that individuals with ID are oftentimes indistinguishable in jail settings. So if you think about the fact that in jail, there's not a lot of opportunity to demonstrate that you are a person in need of assistance or that you have a disability. If I'm provided clean clothes and hygiene products, I'm told when to eat, I'm provided food, I have to stand in a straight line, I have to go to bed at the same time. There's not a lot of opportunity for me as a person with a disability to sort of demonstrate that I need additional assistance. And there's some other sort of processes that I would say are more deliberate that kind of lead to under-identification. The first of which being what's been termed the cloak of competence, or sort of attempts to deliberately mask one's deficits. So saying, yes, I agree, I understand. I don't need to talk about this anymore. We don't need to go over this. Let's just move forward, which is something that frequently happens in the court process and interactions with one's attorney, as well as acquiescence, or yay saying, just, yeah, sure, that sounds good. Where do I sign? Let's move forward. And for these reasons, these defendants are oftentimes not identified at any point. And it really creates a lot of problems, and which kind of has created my role in terms of providing education to the court in terms of these issues. Now, I've mentioned Atkins already, and it's kind of peripheral to this talk here, but I think the Atkins court, the Supreme Court, did an excellent job sort of explaining some of the deficits of intellectual disability and why they're relevant to the legal context. I thought they were really concise and precise about these issues. And these same deficits that they're talking about here are not just relevant to capital punishment. And that is, this court said that individuals with ID have diminished capacities to understand and process information, to communicate, to abstract from mistakes, to learn from experience, to engage in logical reasoning, to control their impulses, and to understand others' reactions. Now, these issues are the reasons in which the Supreme Court said they are not morally culpable for their crimes in the same way that their non-disabled counterparts, and therefore can't be executed. But these same deficits are relevant at all stages in the criminal justice process, ranging all the way from involvement in criminal conduct, so being sort of suggestible, being easily led by their peers. We know that individuals with intellectual disability have a higher likelihood of falsely confessing to crimes they didn't commit. There's more suggestible in the context of interrogation. They're more likely to be victimized. And then these last two sort of issues that I'm talking about here, this failure to appreciate the adversarial system and an inability to testify relevantly, are relevant to competence to stand trial. Now, in 1960, the Supreme Court outlined the standard for competence to stand trial. And the purpose of this was really to ensure that this process is fair. It's to protect the due process guarantees of the Constitution, and basically said, we need to ensure that defendants have sufficient present ability to consult with their attorney with a reasonable degree of rational understanding and have a factual understanding of the proceedings against them. Now, there's a broad literature on this area of competence to stand trial. Most of it's on the process of evaluation, but we do know that competence to stand trial evaluations are the most frequently referred forensic evaluation. And in fact, we're in the midst of what many have referred to as a competency crisis right now, and that states all across the nation are experiencing exponential increases in the number of people who've been referred for evaluations. Some jurisdictions reporting 100% to 200% increases in the number of people referred for these types of evaluations. And there's a number of states that are facing legislation from the ACLU in terms of how long it's taking for people to be seen by an evaluator and how long it's taking them to get into a hospital for restoration treatment. So I say all this to sort of point out to you that this really is a national problem on a pretty large scale. Now I'm going to be focusing on individuals with ID who sort of make up a subset of these individuals, but it's just important in terms of understanding the context that this is a pretty large problem. Now, to be considered competent to stand trial, we've sort of conceptualized this in terms of three prongs. So one must possess a factual understanding, a rational understanding, and the ability to assist counsel. And again, these deficits must be linked to the underlying etiology, in this case, intellectual disability. Others have sort of talked about other capacities that are required, like you have to understand what you're being charged with, to understand the consequences of those decisions. I have to be able to know that what guilty and not guilty means. I need to understand the relation between the evidence and why I might select a certain option and what are the consequences or advantages of that. And I have to be able to help my attorney defend me in that. Now,
Dr. Wood, if I could just interrupt for a quick moment here and ask a question about this. And this kind of goes back to your earlier statement, maybe about people who can drive, and because we think about competency oftentimes in terms of, obviously, competency is a trial. And there's also a competency that we're often looking into, a competency to manage a person's affairs across the course of a day. And so, if a person has a conservator or potential need for a conservator, we're evaluating their competence to manage daily affairs versus manage, the ability to manage yourself within a court setting to, ensure that your rights are being protected and so forth. I just wonder if you might differentiate between those two just a little bit to highlight that fact for our audience.
Sure. Yeah. So, and I think there's a widespread sort of confusion about this because I think oftentimes the other issues that sort of come up here are like capacity to make medical decisions, for example, or a capacity to sort of execute a will or to manage financial affairs. And each one of those really has its own kind of definition for that. And certainly there's some overlap that if I'm unable to sort of make medical decisions or don't have the capacity to make medical decisions, I might also be more likely to not be competent to stand trial, but those are distinct from one another. And this sort of question about being competent to stand trial is really context specific. So when we're doing an evaluation, we're considering sort of what are the charges against a person, what are the decisions that they might be required to make. So there's sort of a difference in terms of if I'm charged with a misdemeanor assault versus sort of an armed robbery where I might be required to go to trial and to testify. What's required of that to be considered competent is different from if I'm charged with a misdemeanor assault where the evidence is very clear, it's likely to end in a plea deal. And so when we're talking about this competency standard, it's really important that a defendant appreciates sort of the factual understanding, which is just the court process in general. Who are the people in the courtroom and what do they do? A rational understanding, which we sort of think about as the ability to apply that information to one's case. So I have to be able to not only recognize that my defense attorney is representing my best interests, but that also means that they're advocating for me. And when I mean they're advocating for me, that means I understand that they're not going to share information that I tell them with the court. And so it's sort of being able to apply this information in a sequential way and sort of reasoning through these decisions. as well as being able to assist counsel. And that's just sort of the basic ability to relay information, to understand what might be helpful in my defense. An example might be sort of evidence that might, or information that might lower a charge from burglary to breaking and entering, or some sort of felony theft to a misdemeanor shoplifting. If I'm not aware of sort of the importance of information or how it might be interpreted by my lawyer or by the court, I might not appreciate or have the capacity to understand that I should disclose that information. And I'm certainly unlikely to do that if I don't recognize that that information is confidential. And so I hope that answered your questions in terms of their overlap, but it's very specific.
You mentioned a couple factors there, cloak of competence that people wear. I mean, this is such a big factor. It actually stretches across everything that we do, because people are often kind of not addressing their needs because they're trying to appear competent when they don't know everything. It's like one of the most important things I think I've learned across the course of my life is to allow myself to be dumb about stuff.
Sure.
And to be able to ask questions so that I can get information. And a lot of people with disabilities are so fearful of that because of, their history, and they don't want to be seen as that person who doesn't know things.
Absolutely.
And then acquiescing, to what they think others are wanting to hear from them or needing to hear from them. So, those couple factors really seem to play a lot into a person's ability to manage themselves within court.
Absolutely. Yeah, and I think that oftentimes what's interesting about that is I think everyone on this call would probably agree with those things and are probably unsurprised when I say that individuals with intellectual disability go unidentified and sort of, don't get identified as someone who should be evaluated. But it does require a lot of explanation to the court. I can't tell you how many times I've had to testify, and the prosecution will say, this woman has a 60-page long rap sheet, but she's never been referred for a competency evaluation, and you're telling me she's unrestorable? And to sort of explain to the court, like, yes, I am, and let me explain the processes that are in place that have made it so that she's gone through 60 pages worth of a criminal record and never been identified as someone who needed an evaluation. And I think it's really unique to this area that this is not something that we would see with someone with like a psychotic spectrum illness, for example, that those deficits are really obvious and in some ways, and that irrational thought process and that inability to sort of apply information and the interference from delusions is really easily identifiable. And those are things that they are episodic in nature, but they're picked up on pretty easily. And there's not really a lot of controversy about that. But when it comes to intellectual disability, you consider these sometimes deliberate efforts to say, no, I understand, don't question my understanding, which sometimes I find in these evaluations I'm met with. Sometimes the defense to that is to get very frustrated and to get angry. And so I'll find that doing an evaluation, a defendant will get very mad at me and say, why do you keep you're asking me the same questions over and over? Why do you keep asking me this? And it's sort of this attempt to mask their deficits in a way that it sort of shuts down the conversation. And so I oftentimes view my role as sort of being an educator to the court in terms of, yes, I don't disagree that this person has a 60-page rap sheet, but I would argue that she's gone through 60 pages worth of criminal offenses and she still can't tell me adequately what a judge's role is. And I think that is more important than the fact that she was not identified. And I would say even fits with the fact that she was not referred for this. So it's an interesting sort of nuanced area. And I think that a lot of my role recently has been sort of educating defense attorneys in terms of, even if you don't think there's an issue, really sort of dig into a little bit further. And this is sort of the broader issue in terms of competence to stand trial. I've sort of mentioned this. The majority of people who are referred for competency evaluations, they are considered competent. So we'll say about 75% that research suggests. And the majority are referred to restored to competence with medication alone. And that makes sense if you consider the fact that most of these individuals who've been diagnosed with a psychotic disorder, competence restoration treatment proceeds through sort of a process where they're committed to the hospital and provided with medication. Now, individuals with intellectual disability do make up a significantly smaller percentage of those referred for these evaluations, so up to about 10%, the literature suggests. But I would argue this is likely an underestimate. Again, sort of the data that we have to suggest that they're under-referred and under-identified. I would argue these numbers are actually much larger. We also know that there's a strong association between IQ scores and competence to stand trial, but also restoration. And so for that reason, again, it makes sense that individuals with ID would sort of comprise this larger bulk of the lower tail. They do have similar rates of competence as typical defendants. So we see that about 3 out of 4 defendants with ID who are referred for competence evaluations are considered competent. But what sort of distinguishes them are their deficits are distinct. So as opposed to a defendant with a psychotic disorder who might have a delusion that's interfering with their rational understanding of the process, individuals with intellectual disability have competence-related deficits that arise from cognitive ability. So we're talking about impaired reasoning. Maybe they're not retaining information in the same way as other individuals. They're not abstracting consequences. And it really requires a different type of assessment. So being able to ask questions in ways that sort of get at this nuanced interpretation. I've already talked about the fact that these deficits are oftentimes masked by various mechanisms. This cloak of competence, this acquiescence. If I were to just conduct a competency assessment and say, tell me what the judge does, tell me what guilty means, tell me what your charge is, and sort of stop it there, I think some individuals with intellectual disability would be able to sort of fake competence in that way. But it's about digging a little bit deeper and ensuring that their cognitive ability is there such that they're able to reason through these decisions. Now, I'm going to tell you that the most important thing that I tell people when I provide this training, especially defense attorneys, as well as forensic examiners, is to never take a claim of comprehension at face value. When you're evaluating a defendant with intellectual disability, ensuring if they tell you that they understand, always seek corroborating evidence. This sort of goes in line with what I had explained, that they're likely to tell you that they get it even though they don't, and seeking any sort of corroborating evidence that they do. I've sort of talked a little bit about some of these deficits that we frequently see, sort of identifying that my attorney represents me, but appreciating kind of what that advocacy role is, that I might accept the advice of counsel, but I need to be able to explain my rationale and those alternatives. So the law does not protect you from making bad decisions, but it does protect you from making ones that are irrational. And so although a defendant might be sort of acceptance or acquiescing to these sort of options, you need to ensure that they understand why that's the decision that they're making, not just that they're agreeing because my defense attorney told me to, but why is that? What are the consequences that flow from this? And why are you selecting this option as opposed to another one? And sort of doing that investigation, that sort of assessment to ensure that they appreciate that. Now, the main thing I want to point out, though, and I think probably the more important piece, is this issue about competence restoration. So for that subset of defendants that are not competent, and these are sort of that about 1/4 of them, traditional methods are unlikely to be effective. And I talked about some of these traditional methods, or psychiatric medication prescribed on an inpatient basis. As you can imagine, a defendant with intellectual disability who's not competent, who needs treatment for the underlying etiology, the intellectual disability, committing them to a psychiatric hospital for medication is ineffective, costly. In some cases, I think you could argue unethical, inappropriate, but it tends to be the way that things are done. The other thing that I'd point out is that many have argued that we should be conceptualizing competence restoration treatment in this population as competence attainment as opposed to restoration. So when we're talking about competency training, we're not restoring ability that's been lost because of a psychiatric illness, like someone who has a psychotic disorder. We're actually providing sort of the scaffolding and the skills so they can be considered competent. So we're helping them to attain competency, not restoring it. And so for that reason, it really is distinct from the larger population of those referred for this type of evaluation. I would also note that what really sort of distinguishes this population is there's significantly lower rates of restorability. So even when we're providing treatment that's effective, that's been designed for individuals with ID, the rates of restoration are much lower than with the larger population. So like 90 to 95% of defendants who are not competent are ultimately restored with medication. When we're looking at defendants with intellectual disability, though, we see that those rates of restorability range anywhere from 18 to 60%. And those 60% estimates are even when we're providing a restoration method that's specific to defendants with intellectual disability. And we would be remiss not to consider this when we're thinking about sort of the procedures that we have in place and what we're doing for defendants who are not competent. And the court sort of addressed this in some ways. So this was a case out of, I think it was Florida, a federal court in Florida, And it highlights one of the criticisms of restoration training in this population, that rote memorization is insufficient. And in this case, the court basically said, all right, so this guy can tell me what a judge does and can tell me what his charges are and stuff, but can you guarantee to me that this person didn't just memorize this information? And in fact, memorization is not competency. And if you think back to the definition that I provided, it's not just, that's sort of the building block. You have to understand those basic facts about the court system, but that's not it. That's the first step. The second step is that you then have to sort of be able to reason through that. I have to apply that information to my case to make rational decisions, to make reasonable decisions, to work with counsel. And so the court's really been cognizant of this to say, okay, so just that factual piece, sure, that's the baseline bar, but we have to be able to ensure that we're doing things more than just rote memorization of this. And I think that these are crucial issues that really need to be discussed a little bit more.
Just take note of the big differential there between circumstances where you're using a formal method of training specific to people with ID versus just a more or less a typical approach to that,
Right.
that you attain a much higher rate of competence under circumstances where you use that specialized approach.
That's right. That's right. And we do see that improvement. So the early studies virtually said, sort of 18%. And the early studies sort of, Patty Zaff did a review of different competence restoration training methods all across. It was part of like a judicial council. And their conclusion at the end was there's really not a lot of data to suggest that competence restoration for defendants with ID is effective. And it's so time intensive, it's hard to justify. But the few studies that they talked about were those that implemented the Slater method, which I'll talk about in a minute, which is actually what the state of Tennessee uses. It's one of the only empirically established sort of methods of restoration training for defendants with ID, but it's still not reaching, we're still not reaching restoration rates consistent with sort of the larger population. But yeah, so we do see that improvement there. And I say all this, so I've spent all this time talking about how defendants with ID are different, their deficits are distinct, that we need to modify the assessment process, that the traditional restoration treatment's not effective. But unfortunately, these same procedures prevail. And I talk about that from my own clinical experience, from sort of starting here, but also the places I've been before here, that under-identification remains standard. I'm still getting referrals for competency evaluations for defendants with ID who have 60-page criminal records that have never been referred for a competency evaluation. I'm seeing defendants who I'm sort of doing the second evaluation or the second opinion about competency. And again, these deficits are going missed. They're not being detected. So I think it's sort of a three-step sort of issue. Number one, ensuring that the courts and defense attorneys are recognizing a defendant who has an intellectual disability. Number two, ensuring that the people who are providing the forensic assessment are familiar with the uniqueness of defendants with ID, that just being trained as a forensic evaluator and not sort of the nuance of intellectual disability, it's likely that these deficits will go undetected. And then finally, number three, and I think most problematic, is that we really need to ensure that our procedures for restoration or competence attainment are effective for this population. And I'm going to give you an example of a situation that I frequently saw in a hospital before I came here. And these are defendants with intellectual disability who were committed to the hospital as incompetent, just like any other defendant. And they would go to the state hospital for restoration treatment. While there, they would have a treatment team who would sort of manage medication, periodically assess, what are your charges, what are your options. And they would be enrolled in group competency training. And what I mean by group competency training was it was usually sort of a big group on the unit, and they would hand out worksheets that sort of had like, hey, this is what a judge does. Hey, this is what whatever does. And usually those materials are written at a middle to high school level. There's not a lot of elaboration. It's in a group format, so it's not individualized. And it's really to kind of just fill the time during the hospitalization until the medications kick in, because we know that's the most effective method of restoration. Well, what would happen in this particular jurisdiction is that there was a statutory time limit, 3 years. And that 3-year time limit was sort of derived from the Supreme Court saying in 1972, you can't indefinitely contain people who are incompetent because it's unconstitutional. And so this particular jurisdiction used a time limit of 3 years. And what would happen for these defendants time and time again is it would approach the 3-year standpoint and the treatment team would say, oh, well, I mean, they've been here for 3 years, they're still not competent, so they're unrestorable, and then they would pursue civil commitment. Now, I would argue, not necessarily they might be unrestorable, but I would argue that we can't make that determination if we're not providing a treatment that's effective to treat the etiology. That certainly, if I have, strep throat, and then you provide me treatment for something else, and then my strep throat doesn't get better, we can't say that it's a treatment-resistant strep throat because I wasn't given treatment to address that. And that same issue is happening here. And what would happen for these defendants, and it drove me just over the wall. I mean, these defendants would be determined unrestorable after this 3-year period where they're provided treatment that wasn't effective, and then they would be civilly committed, which there is no time frame on that. So it would be an indefinite commitment. And it was just unfair in so many ways, especially knowing that there was treatments available, that we could provide restoration training for this population. Which brings me to this.
Well, could I just ask you a question here? This
Sure.
is a little bit of maybe a little bit kind of an overarching question, because it sounds like you take the position that it's to somebody's benefit to be found competent to stand trial. And I don't know, maybe you could articulate how you feel about that piece a little bit. Because, I mean, there's this piece of me that could say, well, maybe it's not to your benefit to be found competent or to be trained to competency, essentially. Sure. And so maybe just kind of sort through your reasoning a little bit as it relates to
Sure. That. Yeah, so I see what you're saying. And I don't know that I necessarily think so much about the sort of benefit of being found competent versus not, so much as in the accuracy of the decision that we're making. And so I think the important part to me is that, and I think in a lot of times, in a lot of these cases, the data really suggests that the outcome is that they're not restorable. And when we make that's not a light decision to make, right? But we also need to ensure that that's an accurate determination. And I think that in some jurisdictions, it's more quote unquote beneficial than others to be considered unrestorable. Now, in this other jurisdiction that I worked in, the consequence of being considered unrestorable was an indefinite civil commitment, which I would argue is kind of punishing.
Yeah, it could definitely work against you under that circumstance.
Yeah. But in a jurisdiction much like here, if someone's found unrestorable, usually the option is, okay, we dismiss the charges and we have to pursue something else, which sometimes is civil commitment, but sometimes it's release to the group home or ensure that we've got DID involved, that they're providing services. And so it's not so much a value judgment on what's the benefit of being competent versus not versus the court, and I think we all should be interested in accurate determinations, regardless of sort of the consequence. And so it's really an interest in accuracy, but I would argue in this other jurisdiction, I think the other sort of consequence should be considered, that it is punishing to make a wrong determination there.
Yeah, that's great. Thank you.
Sure. So this brings me to sort of the main point here, and I would be lying if I told you that this wasn't part of my decision to accept the job at Vanderbilt, was this uniqueness of the system here in Tennessee. And I think Tennessee in a lot of ways sort of represents what I would call a model program in terms of how it deals with defendants with intellectual disability. In my experience, most jurisdictions treat defendants with ID identically to other defendants. Dr. Fikes is actually on the call today. He oversees sort of the forensic services through the Department of Mental Health. In the state of Tennessee, all forensic evaluations are provided on an outpatient basis first. And the majority of those who have competency concerns are sort of deferred to the inpatient hospital, and that's where they would make a determination. And we see similar rates as sort of national estimates, about 27%, which is consistent with what we know from meta-analytic research for those that have competency concerns. Now, a defendant with intellectual disability who the outpatient evaluator believes could be restored or sort of could attain competence, assistance from DID is requested. And what happens, and this is sort of that second step that I was talking about, that sort of being able to ensure that someone is sort of attuned to these deficits, but also that they're being provided treatment that's adequate. At that point, training is provided by an expert in intellectual disability through DID. They're provided a modified version of the Slater method, which I've mentioned is one of the only established competence restoration training programs for defendants with ID. So this program was developed in a hospital in Rhode Island at the end of the 90s, early 2000s. And it was designed specifically to accommodate the unique needs and strengths of defendants with intellectual disabilities. So they simplified the content, they simplified the language, they ensured that information was repeated early and often. They provided it sort of on the factual basis and then elaborated upon it with a sort of person who's trained in intellectual disability. In some cases, this individual, this expert who's providing this training will serve as a liaison and sort of facilitate interactions with the attorney and sort of help them in the courtroom. And there is established empirical support. So as I mentioned, these studies have suggested that higher rates of restorability compared to treatment as usual when using the Slater method. Now, at the end of this training, the examiner from DID ultimately opines whether or not the defendant has been restored. And so this is from this really fancy forensic services manual that Dr. Fikes and his team publish every year. It sort of talks about the evaluations in the state of Tennessee, how many people are being seen. And you can see here that in those outpatient evaluations, about 3% had a primary diagnosis of ID. So that doesn't include the people who maybe had a primary psychiatric illness and ID was a secondary diagnosis. But you can see these numbers here within this red square are the number of persons who were referred for this outpatient training in the state of Tennessee. I've limited it to fiscal year 2014 and beyond because there was a statutory change at that point that limited the number of people who were referred. But you can see that kind of on average about 30 people, 30 defendants every year are referred for this outpatient competency training. And this is through the Slater method that the expert would go and visit them either in the jail or they would have them sort of brought out to them. Which I would argue really is a model program in terms of providing this, especially based on my experience in other jurisdictions that really treat these defendants identically to other ones. And so future directions, I think this is sort of the important part. This is currently underway. I've sort of been in talks with Dr. Davis as well as Dr. Fikes and sort of collaborating because I'd like to empirically investigate the system. I think that right now we know sort of systemically it's a model program, but there's questions that I think would be important to answer and that I think would be of national interest. First of which being, what is the prevalence rate of intellectual disability in these court-ordered referrals? We know that 3% have a primary diagnosis of ID, but how many have a secondary diagnosis? Number two, how many of these cases are being determined unrestorable on an outpatient basis? So these are the people who would be sort of diverted from that training altogether. They would be people that I see on an outpatient basis, and I say, this person is too impaired, and even if we provide them 16 years of Slater method, we're never going to get them to a point that they could participate in their defense.
And I'm correct, Dr. Wood, that is not, we don't have that information.
That's right. So that would be something that would exist sort of at the forensic outpatient level. And so that's another question because there's people, so we know how many people are referred to you, but we don't know how many people get diverted before then. Yeah. It's also probably unknowable how many people sort of have interactions with the police at the crisis level and never even get arrested. And so I would suspect that those people are with the more moderate to severe forms of ID, and there's some data to suggest that. But I think that we're sort of whittling down that population along the way. It'd be nice to be able to answer those questions as well. But, certainly we can only know what we know, right? And then the last questions are really related to, how effective is this? So when we're providing this training, how many are restored? And how quickly does that happen? How many sessions? How many times is a ID expert seeing this person and providing this training before determining that they might not be restored versus saying this person has been restored? What is the content of these sessions? How effective is it? But ultimately, I personally, and I don't think I'm alone in this, think this is an incredibly important venture to understand. I think there's not a lot of people having this conversation. I think a lot of particularly forensic mental health experts sort of recognize this as an issue, but have difficulty sort of isolating this population, sort of understanding what we do here. And I think that this is sort of an important time to have a partnership and kind of understand these data that really Tennessee in a lot of ways and could be a model for other states for how to proceed here. And I did want to provide a couple of sort of resources here. So these are just resources in terms of meta-analytic research about competency to stand trial. I published put the Forensic Annual Services report here, as well as the articles about the Slater method and standardized treatment for restoration. So that's sort of I wanted to sort of share with you all.
Oh man, that is outstanding, Dr. Wood. Just really appreciate everything that you brought to the table there with that presentation. And it's such an important topic. I think a lot of people don't interface with it real regularly. And
Sure.
so there's a big learning curve for a lot of our service system out here whenever they encounter a situation where they've now got to interface with courts and other parts of the legal system. And this is just, I think, tremendous to be able to give people more information about this from someone who's studying this topic and
Sure.
keeping up with it. So really appreciate that. Michelle, there were a couple of comments in the chat box. Can you review those and pose any questions that people may have had or just comments that people had?
Yeah, absolutely. So I'll just point out a few things that are in the chat box and then get to some of the questions. So I did post a link for the information about the legislation mentioned related to the capital punishment and intellectual disability. So that is in the chat box if you would like to learn more about that. Dr. Fikes added as an example to something that you were saying previously, Dr. Wood, just because a person has a conservator does not mean that they are automatically incompetent to stand trial. Treva mentioned, I don't understand competence restoration for folks with IDD who can repeat after me like you mentioned. So can you provide more information on that, please?
I think I understand what that's asking, but I'm not entirely sure. So I think that's sort of getting at the issue that that I was mentioning in terms of just being able to sort of memorize information or repeat information after an evaluator. That's not competence. And I think this is, in fact, one of sort of the broad criticisms of competency restoration training or the Slater method with this population, is that some have argued, are we not just training these individuals to memorize information and then sort of sufficiently explain it? And that's what I mean when I talk about sort of it really increases the demand on the attorney, but also the examiner and the court to ensure that they've not just memorized it. And some of the ways to sort of get around this is to never take a claim of comprehension at face value, provide sort of different scenarios like, okay, so you say that you understand that. Well, what do you think about this situation? And try to provide questions or ask the questions in different ways or with different sort of scenarios to ensure that they're not just saying that they understand it, because frequently 9 times out of 10, they'll say that they understand it. And it's really our responsibility, our ethical responsibility to ensure that that's not just saying that they understand it, but truly do.
Yeah, we have a lot of people that we serve in our service system with autism spectrum disorders who may well be able to recite for you every word that you've said, and yet still have difficulty applying that in a real life situation. Very important point.
We had another question. Can you repeat the court case mentioned? I believe it's referring to the Atkins case.
Yeah, so there's Atkins, and then the case he was talking about, rote memorization. It's U.S. versus Duhon, D-U-H-O-N. I think it was in 2000 was the case that addressed that. There's also been a couple cases that are mentioned in one of the references that I talked about. It was written by myself and a couple colleagues with courts that have addressed the issue of kind of reasonable accommodations and sort of how that's distinct from the measure of competency. So if we can provide someone with maybe a note taker or someone to sort of facilitate communication in the court, how that might be something to sort of allow someone to be considered competent. And that's sort of a separate discussion, but certainly related.
We had another question about what effective restoration treatment looks like for ID. I think you kind of answered that in your presentation. So Janet, if you have any additional questions surrounding that, feel free to type them in.
She also wants to know, does you have any funding for your program? She corrected it and said, do you have funding for your research that you're doing?
I would love some. I'm searching for some if you are aware of any.
So Dr. Fikes posted a link to his annual forensic report, so you can check that out. Janet would like to know, would this kind of training, I'm assuming competency training, be useful prior to criminal encounters?
You know, that's an interesting question. And I've seen some conversations in the literature. I think that most of this is sort of happening in the special education literature. And most of it's sort of centered on the conversation that I think is more relevant to capacity to waive Miranda, in terms of how does one interact with police officers? If you've been arrested, what should you do? And sort of this training in terms of asking for a lawyer and that sort of stuff. I've not seen sort of specific iterations in terms of training about the criminal justice system. I think that might help the factual component, but certainly that's not going to address the reasoning deficits that I think is the more likely culprit of someone being considered not competent.
I would like to just jump in, if I could, to comment that what we are mostly interested in prior to this is diversion from arrest at all.
Yes.
So this is where I prompt Dr. Davis to mention some recent initiatives around START and so forth that could prevent the criminal justice system from being involved in the first place.
Mm-hmm.
Yeah, that's great. Yeah, because, and I actually thought of that as you were going through your presentation and talking about people who might be diverted at the, at the level of not even encountering the police or being involved with the police. And that's actually a large part of what we're trying to accomplish with a new program that we just actually hired 20 people for. We did get 20 out of our 25 positions filled because we're developing a crisis system that is specific to people with intellectual and developmental disabilities. The goal of this program is going to be to basically divert people at the point of crisis. In fact, to try to prevent even a psychiatric hospitalization, if that can be prevented, and utilizing other resources to be able to deal with that. We're working with the Center for START Services out of the University of New Hampshire. They're consulting with us on the development of this program. And so some of the data that you were seeking, we may be able to kind of seek a merger between these two programs, to try to get a good picture of the whole system, essentially, and how it operates.
Yeah, I was thinking that as far as the data as well.
Yeah.
I would love to be put out of this work if that meant that people with ID were not in this situation. It's created a niche where this is necessary to have these conversations, but ultimately, I think that that's sort of the point at which this conversation is important. I would love to be out of a job for that reason.
Yeah, I don't think we're going to be out of jobs as it relates to all this, unfortunately. But I do hope that we can improve the way that we respond in these circumstances. And so everything that you've been talking about fits like a hand in glove with everything we're trying to accomplish in DIDD.
Yeah, and I added the website for the Tennessee START Assessment Stabilization Teams if anybody wants to learn more about that, if you haven't heard about it from us enough at this point.
And Dr. Wood, I just want to ask you briefly, real quick, and I know you could spend an hour on this topic as well, but can you let the folks know that are listening a little bit about malingering and the difference in how we're making those determinations?
Sure. In terms of how we assess for malingering.
Yes, ma'am.
So malingering, that's a great point, and I did not mention this at all because it's a unique issue with intellectual disability. But every forensic evaluator in every case is always considering the prospect of malingering, and this is always something that we need to be ruling out. I would note, however, that oftentimes the opposite of malingering is present in these cases, whereas that there's a genuine intellectual disability history and genuine competence deficits. I in fact find the opposite, that these defendants are going to great lengths to mask their deficits as opposed to show them to me. And so when I talk about this sort of cloak of competence in the jail, some examples that I've seen are people checking out books even though they don't know how to read. They're getting assistance filling out their canteen forms, but they're not disclosing that. And during the evaluation, they're telling me, yes, I understand. How dare you question my knowledge about this? And so in fact, it's very much a reverse process than we would see in a typical evaluation where malingering is always at the forefront of our minds. I will say that in evaluations where the person immediately sort of starts off by saying, like, I have a history of intellectual disability or I can't read or write, red flags kind of go up for me because, in fact, that's a very opposite process than what I would expect and oftentimes find for defendants who have these deficits. But certainly that's always something that we're considering. I think this would be a topic for a whole nother day, but the methods that we as forensic professionals have to evaluate malingering are not very effective in this population. They're not useful. The data that we get from them are really only useful in certain circumstances, and many have argued against their utility in this group. But I would sort of say that the short answer is that malingering is rare in this population, and oftentimes it's sort of the opposite is what we see.
Thank you for that. We may have you back on for malingering. That could be a whole other hour-long program.
Great question, Ray. Thank you for that.
We
And
had a
thank
few
you,
other-
Dr. Wood. I'm sorry.
I was just going to say we had a few other questions if you want me to get to those.
All right,
I know we only got 1 minute left.
Yeah, we only got 1 minute. Go ahead, quickly.
Dr. Wood, is it okay if Travis shares your contact information with the State Public Defenders Conference?
Oh, absolutely. Absolutely.
And you did already say that you would be providing the slides.
I will email those, yeah.
Chris had a comment that NAMI offers some relevant programs for interactions with police and court training. Patient-Centered Outcomes Research Institute might be interested in the funding, I believe is what Janet is referring to. So they've just begun research on IDD disparities. And I believe that is about it, other than Janet would be open to brainstorm about funding possibilities. You can email her if you'd like to.
And so, James,
Perfect.
We'll work with her on that.
I will definitely do that.
At Vanderbilt, and she's with the Vanderbilt Kennedy Center. And
Oh, okay.
So she could
Perfect.
help you with that. So, wow, just appreciate you so much, Dr. Wood. Thank you so much for being here today.
Thank you for having me. This was wonderful.
Fantastic presentation.
This
And
was great.
really helped our audience, I think, get more educated on what this is all about. I think kind of establishes the way for this partnership that we're wanting to have with this research that you want to do. I'm very, very interested in us participating in that. So such a great thing. I appreciate you so much. Appreciate all of our audience for being here today and tuning in. We had a great turnout today. So, spread the word about this. It's important stuff. And we do this every Tuesday on the Clinical Consultation Network, 12:30 Central Time. So everybody, you're welcome to join us for all of our wonderful presentations. We've got a great one coming up next week from a couple of folks at the Middle Tennessee Homes. Is that right, Michelle?
Yeah, we've got Sarah Burke, the BA, and one of their SLPs talking about the function of communication.
Okay, so this is going to be something great. I will not be with you next week, but Michelle is going to step in and be the host in my stead. So very happy to have all of you back again next week for the Clinical Consultation Network. Again, thank you, Dr. Wood. Thank you, Dr. Fikes, for being here as well. Appreciate all of you guys, and we'll see you again next week.